Hi, it's Anne-Marie from Charmed Life Therapy back with an update on the Lively-Baldoni saga. It's a funny one today. I was like a lot of people tuning into either Els Rich or Lauren or Popcorn Planet last night as we had these messages released between Wayfarer and the various parties and Jed Wallace and all of the rest of it to do with the creation of the lawsuit info website. And it's just kind of beggars belief to us all out there because Blake Lively keeps having unsealed or whatever it is, or suddenly something becomes unsealed for one reason or another that she thinks is useful to her case. And we're all sat there thinking, oh, why are we not looking at the same thing? Why is Blake Lively seeing something entirely different to what we're seeing when we see these messages? It's like the last time this happened and there were like text messages unsealed. Um, and I think I made a video where I accidentally thought it was like Wayfarer that had done, like that it was like pro Wayfarer rather than it was pro Lively. And it was on the afterwards. I thought, oh, actually, that's from Lively's camp. Why do they think that proves their point? And it's like they're looking for that confirmation bias all of the time. Now, surely it has to be from Blake herself. Surely her lawyers are not that dense. Or are the lawyers looking for confirmation bias too all the time? I mean, a big part of this case seems to be this idea of Blake's ever-changing case because she needs to find that proof from somewhere, and it's not in her head, and it's not in her own messages or her own communications or anything like that. It has to be coming from the external. She's wanting that confirmation bias to prove an idea in her head, basically, or a thought about something. But the lawyers surely don't have that same excuse. So this, all of this text chain, can you stop coughing and spitting? I'm making a video. Do you know? There's no respect in this house. so, so all of these messages between Jamie Heath, Brian Friedman, Jason Sunshine, I think Summer Benson is on there, Rosa Kalantari, all of the people to do with the production of the lawsuit info website. Somehow Blake feels that this bolsters her argument about getting treble damages for retaliation. And it's like, Blake, there's no secret here. We all knew about that website from its inception. We knew it was coming. We were all forewarned about it, including yourself, that that was exactly what was going to happen. And that's exactly what they did. There was no mystery, no skullduggery, no collusion, other than the means to get it done with like Rosa from the Skyline Agency who put it together, got it out there. So all these messages basically said, and I thought, well, there's no point reiterating them because they're all pretty boring. It's basically, I can't see it. Can you see it? Is it up yet? I don't know. I can't see this and I can't see that. Can you see this so and so? Yeah, blah blah. No, it can't go up like this. And actually the whole tone of it is this has to be as right as possible. It has to be correct. It can't go out looking like that. There's an attention to detail needed. Brian Friedman then weighs in and says, oh, just get it out there and we'll tweak it later. And can't we change the name of the domain to this? Which, as many people have pointed out, is often frustrating when you've spent ages on a project and somebody comes along and thinks it's so easy to just change a fundamental part of what you've set up. They come along with a good idea, don't they, and try and blow up your whole project. You're a bit like one of those. And Jamie basically says, Brian, I love you, but I don't think so. And it's just entirely normal communications. I don't think there's even a swear word among it all. And somehow Blake interprets this as ammunition about a retaliation and defamation campaign. And it's like, and you just, and I think that's what we're all struggling with is this idea of what is it going to take to help us see the truth. And like we say, we know that people like Melissa Nathan and Jed Wallace can do certain things that we probably wish they wouldn't do or wouldn't like them to do, or they've done it on behalf of other people. But it does not necessarily mean that they've done it in this case when they're dealing with people like Jamie Heath and Justin Baldoni and Steve Sarowitz, who have faith behind them and want to do things in a certain way that have been thrust into this, against their own wishes and feelings, and the last resort possible that they wanted to have to get involved with. They've had a no-win situation in essence. Um, so there's all of these aspects going on to the case which are interesting, I guess, that we know there can be bad actors on all sides, and in the middle, for many of us, we feel there's this little tiny microcosm of good people. We've got good people, questionable people, deluded people, nefarious people, money-minded people that want to profit off it. There's a bit of something for everybody in this case, I would say, which is kind of why it's fascinating to us all. It's interesting. I'm reading a lot about my own human design chart at the moment and trying to figure it out in a non-professional way because it's not my speciality. But apparently, I'm looking. I had a little meeting with a business specialist in human design the other night, and she goes, "Oh, you've got something that 99% of the charts I see don't have." And I thought, I know this isn't going to be good. And it turns out I've got four completely open centers, what they call. So I'm still fathoming out what that means in terms of my messaging and what I put out there and what I speak about. But it can mean, because I've got an open throat, it can mean that I can get like overstimulated and overspeak, or I can actually be quite good at looking at all of the arguments, all of the storylines out there. And actually, if I'm in good form on any given day, I can be quite good at picking out the salient details from every form of argument. So I think that kind of makes sense for me as to why some days I just don't feel like commenting on this case at all, because I feel like it's been well done and thoroughly done by other people. I feel like I've nothing new to bring to it. So that's why kind of just recently, I think there's possibly been more gaps in when I feel moved to present to you in this sense about this case. But let's just have a look at a few little docs, not to go over in anything in any detail, and none of them are particularly long. So it should be helpful, hopeful. And just thank you to that girl Has No Filter, who has been very nice in my comments to me and asked me not to stop sharing my ideas and my thoughts about this. So let me just bring this up. So we're sharing, I believe. So where did I want to start with this? Let's have a look. Yeah, we'll just quickly read this one. So this was dated September 15th. So was that 2 days ago? What date are we on? We're on the 17th. So I'm a bit behind. So this is Blake's law firm, obviously. So, dear Judge Lyman, on behalf of Blake Lively, we write pursuant to individual rule and rule 1 of attachment A to your honour's individual practice in civil cases to respectfully request that the court continue to seal portions of the memorandum of law in support of Ms. Lively's motion for treble damages and punitive damages, as well as the declaration in support of the motion and Exhibit 1 to the declaration, the sensitive materials. For the reasons described below, Ms. Lively respectfully requests that the sensitive materials remain under seal. So that's basically this statement, this affidavit from this mystery person on the mystery set, where they had Justin Baldoni allegedly excommunicated from his own set and his own production, or certainly one of Wayfarer's sets or Wayfarer's productions. So Ms. Lively respectfully requests the continued sealing of the sensitive materials which reveal the identity of a person who has disclosed a prior experience of verbal abuse with defendant Justin Baldoni in this action. And this is kind of the little bit that I feel moved to speak on, because I mean, we had this argument anyway that what Blake is accusing Justin of is SH and retaliation and the various other things, the collusion. What she's not accusing him of is verbal abuse necessarily, not in any legal context, at least. I mean, she's accused him of fat shaming her and such as that, but she's is verbal abuse in this context a legal claim? It's not inciting violence or anything like that, or battery or assault or anything like that. So this statement, obviously, what we know from people who are more legally minded is that she shouldn't be able to bring in onto this docket anything that doesn't directly relate to the exact same behaviour that Justin is accused of in her legal filings, in terms of the case she brought against him. So she's suing him for SH, and now she's bringing in somebody else external who experienced verbal abuse, a completely different thing. But it brings into this question, doesn't it? What are we talking about in terms of verbal abuse? I mean, I mean, for me yesterday, I was kind of busy minding my own business and rejigging my website because my booking calendar needed to change. So I thought, right, I'm going to brainstorm. I'm going to narrow down what I'm offering. I'm going to simplify things. I'm going to make my life easier. So all day yesterday, I spent on my booking calendar and my website and really thinking about how I want to work in future. And in the meantime, just between checking YouTube occasionally and comments, I was also being called a white supremacist, a bigot, a fascist, and all manner of other things for having commented on, my brief comments touching on my own personal sadness of the political assassination of Charlie Kirk. So I was being called all manner of things. And so it kind of tickled me a little bit when this verbal abuse, this statement, this affidavit, whatever it is, what are we talking about in terms of verbal abuse that is so bad? Because we're seeing like these messages, these signal chats or whatever it is that Blake feels are going to bolster her argument for treble damages. We're now seeing them. And as we said, there's no smoking gun. There's nothing here. So in terms of this document that she wants to continue sealing the person's name, it's like, well, what are we talking about? Is your interpretation of verbal abuse completely different than our version of verbal abuse? Because yesterday I was getting a lot of verbal abuse basically in text form. I have a feeling that Justin hasn't been calling anybody on a set a bigot, a racist, a white supremacist, dumb. I was being called all sorts, uneducated. I was wrong in terms of hatred not being useful out in the world, all sorts of things. And I was kind of reading it dispassionately because I think this is the thing. When you descend into hatred, it really makes you stupid. Hatred will make you stupid because it narrows your field of vision. You stop hearing anything external to the argument in your head. Your feelings are all locked on one direction. So hatred, and why I kind of steer you away from getting really hateful about Blake or anything in general, is because it makes you really dumb and it makes you vulnerable. It makes you really vulnerable out in the world. And I don't want to go on about Charlie Kirk because I know like it's not for everybody. And it's not like I think he was some perfect person, but I think the interesting part of him and what he focused on was this idea of people in university not getting a one-sided education, not only getting a one-side perspective of things, which I think was his fear, So that was what interested me about him, I guess, this idea of, where am I undereducated? Where can my perspective be open? That's what I personally found interesting about him. Other people see it the exact opposite, and they're entitled to their opinions. But where I would strongly suggest nobody finds helpful is hatred. Hatred, I don't think, is one bit helpful to anybody over anything. And if you're going out into the world full of hate, the first person that's going to get hurt is yourself, without question. Anyway, that's my undereducated opinion of it, if you like. So, yeah, so Blake wants to continue sealing the name of the person who experienced verbal abuse from Justin Baldoni on a production that's allegedly not the Ends With Us production. So Exhibit 1 was produced and designated confidential by Ms. Lively pursuant to this court's order and protective order, and contains information of a personal and identifying nature regarding an individual that warrants continued sealing of the exhibit. Further, the redacted portions of the declaration disclose details regarding the declarant that, if disclosed, threaten to reveal the declarant's identity. So she's just specifying which bit it is there. Don't need to do that. Doing so is warranted here, where the public release of the sensitive materials would subject the declarant to an increased risk of exposure to harassment in the press and or by social media users who closely follow this action. Indeed, the court has previously recognised the uniquely public and media-driven nature of this case. This is a case as to which there has been a lot of public attention. The details of this case have been closely followed in the media. To that end, the declaration has already received substantial media coverage, and in brackets that should read, which is exactly what Blake wanted. It was exactly the headlines that she wanted, which is the whole reason the declaration is on the docket, and will certainly invite additional coverage and frenzy should the declarant's identity or identifying information contained in the declaration be exposed, which surely the person making the declaration understood at the time they gave Blake that statement. So on social media, this coverage includes attempts to unmask the declarant while describing the declaration as PR and lies. There is no public interest in exposing the declarant to 6 months of online scrutiny and attacks leading up to the trial, regardless of whether the declarant ultimately serves as a trial witness. I don't think there's any intention of this person serving as a trial witness. The relevant portions of the declaration and the substance of the relevant information from Exhibit 1 are in the record, such that any public interest in the evidence is already available to the public. Under these circumstances, any limited interest the public may have in the identity of this individual is heavily outweighed by the countervailing interest in protecting the privacy interests and well-being of a third party. So let me just look at that for a second. Yeah, I don't think I can speak more to anything there. I'm just trying to get my head around it there for a second. I don't think we need to read any of that. The proposed redactions are narrowly tailored and consistent with the presumption in favour of public access to judicial documents. And she's noting some headlines there. Justin Baldoni accused of verbal abuse on second project. I had repeated negative interactions. But this is only really clarifying that it brought out negative headlines against Justin Baldoni. It certainly didn't hurt Blake, did it? So it's like it kind of demonstrated that she got positive PR out of it, really, in a way. So that's it. So that's that one. So I thought that was worth commenting on, just over this idea of how bad of a verbal abuse accusation are we talking about? Because in any walk of life or in any job or in any personal relationship or any encounter with a random stranger on the street, I remember it's like once for me when I lived in Castleford, which is a little ex-mining town in West Yorkshire. And so, like, it's not a busy place once you get off the main run through. I like accidentally went down. In fact, I didn't even went down. I think I just was parked like the wrong direction on a one-way street. So I'd accidentally gone down the wrong way, but pulled in, so I was parked. Just literally just around the corner. And a car passed by with his window open, and my window happened to be open, and he just said, "It's a one-way street, you CUNT. You stupid CUNT." He might have even said stupid effing CUNT. And it's like, could you be bothered? Like, just the, and that's what I'm saying about hatred and vitriol. And when you spew names and insults at people, it makes you look really dumb and really uneducated. And that's, and that, I kind of just sat there in like, so I thought, well, like, even though I'm pointed the wrong way, I'm not moving. I wasn't endangering anything. There was only him in the vicinity. He just fancied having a pop at a woman, basically. So it's like what I'm saying here is, come on, Blake, what are we talking about in terms of how bad can it be? What do we truly believe that Justin Baldoni has been on a set calling somebody a CUNT or whatever it is? It's all just bluster to my mind. It's all designed for PR, isn't it? It's not designed to come out or be revealed, because if it's exposed, it's likely to be in a similar manner to these messages that have been backwards and forwards in terms of that website coming out. So yeah, so that is just my thoughts on that one. So this one is from Prior Cashman. So this is in the Jones versus Abel case. So Judge Lyman, for non-party Katie case, we respectfully respond as directed to plaintiff's letter motion seeking to remove the AEO designations from certain portions of Ms. Casey's deposition testimony. We respectfully submit that the designations should remain, or alternatively that the court should consider amending the governing protective order to provide another tier of protection for sensitive information like that at issue here. As shown by the relevant transcript excerpt, the requested de-designation would affect Ms. Casey's testimony that her employer's principal, so I'm assuming by employer's principal, that would have been at the time Melissa Nathan's client, I imagine. Imagine that's what that means. Had asked Ms. Case to draft copy that later appeared on the StephanieJonesLeaks.com website and in several tweets, and that Ms. Case had been told by her employer that her work was for a prospective high-profile client of the agency group, namely. So I'm imagining it's whoever the principal is. It just means somebody that is paying Melissa Nathan in some way for something. I think that's where it'll be. Correct me if I'm wrong out there. A lot of you people know way better than me, and I'm open to learning, as long as you don't call me a racist and a white supremacist. This case testified that she did not know whether the statements about which she testified were true. This testimony was designated AEO because Ms. Case had testified as to statements made to her by her employer about work for a potential client of TAG, as Ms. Case then understood. So the thing with Katie Case is, although she worked for TAG, I believe she also previously worked for Stephanie Jones, so she had a lot of personal knowledge of Stephanie Jones. So I think what the undercurrent here is that Katie Case may have produced like documents, and the stuff has ended up on the StephanieJonesLeaks.com website and possibly in tweets. But what she created, what she pulled together, I believe she believed to be true, or she knew from personal knowledge. So she kind of didn't question it, I imagine, and possibly she didn't know where it was going. So Miss Case testified that she did not know whether the statements about which she testified were true. So I don't quite understand that part, because what I understood from what I've read so far is that she didn't believe she made like a false information. You know, like whatever she was asked to do, she believed that what she came up with wasn't false. She believed it to be factually true. That's my understanding of it. So I don't understand some of the other bits around it. So this testimony was designated AEO because Miss Case had testified as to statements made to her by her employer about work for a potential client of TAG as Miss Case then understood. So I'll come back to the footnote in a second. So this designation is proper under paragraphs 1A and D of the governing protective order, as this was work for a then contemplated client who is not a party to this litigation, this being a reasonable wording of the word client under the protective order, which kind of states that if there's a chance that there would have been a client or it was discussed or whatever, then it comes under the provision of client. And because at this point the identity of who allegedly requested the website be made does not bear on the truth or falsity of any allegations now in the operative complaints, it becomes who is the mystery person, doesn't it really, that wanted the website. But other considerations strongly favour maintaining the designation over the subject testimony. First, the testimony de-designated and revealed would risk turning this case into a matter of public spectacle, or more of one than it already is, injecting whoever this name is. That's not an overlong name, is it really, in terms of the size of the redaction? On the basis of untested second-hand information would be more inflammatory than probative, at least until directly related to any amended pleading, because after amendment, such information would become judicial and subject to the presumption of public access under that case law. As a result, although plaintiff's counsel indicates that plaintiffs might sue, now that looks even a shorter name, doesn't it? As one of the named defendants, public disclosure ought not to be risked at this time, given the embarrassment and harm posed to an individual whom plaintiffs might never involve in this action. So who do you think the mystery person is that wanted the Stephanie Jones Leaks website? It's interesting though, isn't it, though, how she's after the whole Van Zandt palaver and all of that, that she's going after 10 unnamed Doe defendants as part of her legal strategy. It's kind of, some people might say, karmic, isn't it? That, she was part of the Van Zandt, which listed no named defendants and was a fishing expedition, that her own thing is reduced to having defendants. It's quite funny, really, in a way. Second, plaintiff's assertion that the testimony would remain confidential is cold comfort. Under the protective order, there is no presumption or expectation that confidential information will be filed under seal. As a result, such information can be publicly disseminated through judicial filings. And while an interested party may move to seal such information, such post hoc sealing is an incomplete remedy. Bells cannot be unrung. To the extent that the court is inclined to de-designate the challenged testimony so that plaintiff's counsel are allowed to discuss it with their clients, Stephanie Jones must be sort of being driven crazy by the not knowing of it all, not knowing the name. We respectfully submit that potential revisions to the protective order should be considered. Indeed, Miss Case's testimony establishes that discovery in this case will implicate considerable information that may not meet the letter of attorney's eyes-only information under the protective order, but that is so sensitive and inflammatory that merely designating it as confidential could be insufficient. For example, Miss Case testified about specific instances involving other high-profile figures that established that certain copy about which she testified was true and non-defamatory. That's what I'm saying. I feel like Katie's caught in the middle. I'm not saying it isn't wrong where some of this stuff ended up, but the problem is, for Jones, if it's true and non-defamatory, what do you sue them for? What, in a way, it's like, what is the problem if it's provable information, if it's factual? Those AEO designations, tellingly, are not contested by this letter motion, but if abided, would prevent plaintiffs' counsel from informing their clients of information disproving their pleaded claims. Plaintiffs thus cannot legitimately argue for de-designation of the untested statements made to Miss Case while suppressing other material information detrimental to their client's position. But the protective order broke as this result. Amendment of the protective order to add an intermediate highly confidential tier covering information that a disclosing party affirmatively believes should be filed under seal under the Second Circuit's analysis and its progeny could resolve this issue. Given that this is not presently before the court, we respectfully submit that if the court is inclined to de-designate this case as testimony, the court should consider requesting briefing from all affected parties on this case. That's a pretty decent letter, I think. So it's interesting, isn't it? Sometimes it's these smaller things that are far more interesting than the big reveal. You know, like, because it was so disappointing, wasn't it, last night? I mean, for those of us who are Team Baldoni, when you hear there's like, you know, you suddenly see Popcorn Planet or whoever pop up and it's like, oh, join us live because so-and-so's like new messages unveiled or unsealed or whatever. Oh, all right. And you're kind of a bit scared because you think, oh, what if it's something that I don't like the sound of or paints them in a bad light or whatever. And nearly every time this has happened, you sat there thinking, this is so boring. The messages between these people are just so ordinary and mundane. And like I've spent all day dealing with these kind of messages. I don't want to be kind of listening to it on an evening as supposedly some kind of big reveal that is not a big reveal, as it turns out. So sometimes it's these smaller seeming issues that maybe aren't being covered quite as much that kind of are a little bit more interesting, I think, to me at least, I think. As somebody said, it is interesting kind of how hands-off Justin seemed to have been throughout this process. Now, whether that's because Justin is a really, really sensitive person and they didn't think either that he was up to it or that he would be helpful and they just sent him off to Hawaii and said, just keep a low profile, look after yourself, look after your family, whatever it was. But Jamie, he definitely seems to be a different personality type to Jamie Heath than, say, Steve Sarowitz, doesn't he? They seem to be, from what I can tell, I think Steve Sarowitz is probably a bit of a tough nut, but I imagine he's fair, but I imagine he's somebody you don't mess with either, you know, that will say it like it is and the rest of it. Jamie, I get the sense of, is quite firm but fair and kind. Justin's kind of more of a little bit of a mystery entity. I might have to go off and consume more of his content, but I think he's more ethereal, isn't he? I think he's more in his emotions and the rest of it. So, but it was interesting that he was totally hands off with this discussion about the website that was, you know, all the messages that were revealed yesterday. So this is, I think this is a Kevin Fritzy, but it's not up to his usual standard. It's slightly boring. Not slightly boring, but it's just not as it's not got as many bells and whistles as usual. So it's about Jones and Abel. So as counsel for Jennifer Abel, blah, 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 in the Jones case, we write in response to Stephanie Jones' party's motion to de-designate the deposition testimony. So the same thing under the protective order. So let's just run through it quite quickly. I might just pause the recording for a second. Shall I pause it? I'm always a bit worried if I try to pause it that I'll just lose it entirely. So I might not. I'm still not very professional about this. So specifically, the court determined that the disclosure to the parties of certain information that will invariably be exchanged during discovery, but which may not be necessary to the prosecution and defence of the case, presents an incremental risk of annoyance, embarrassment, or oppression that cannot be effectively controlled simply by the court's model protective order. So the court reasoned that these cases involve business competitors, that discovery will necessarily include confidential and sensitive business information, that several individuals and corporations on each side are in the business of public relations, and the details of the litigation have been closely followed in the media. Moreover, the court held that trade secret information such as the client list is worthy of an AEO designation, and that the same protection, if justified with respect to business plans for and of non-party clients, confidential strategies. In sum, the court's justification for the inclusion of an AEO provision in the protective order demonstrates that the word clients in section 1 should not be strictly construed to solely mean actual clients, as the Jones parties contend, but rather also to prospective clients. So when I was originally going through this, I was trying to get my head around, is this to do with the Rebel Wilson thing? Is it to do with that? That's all I could think of just off the top of my head when you're trying to think in terms of a so-called named high profile person that may have been a prospective client at the time. That's all I could think of really. But there might be various others. I might be totally wrong in that. It is important to highlight the material difference between the Jones party's characterisation of Ms. Casey's testimony with respect to, and it is a relatively short box, that, isn't it? Could you put Rebel Wilson in there and what Ms. Case said? Although the Jones parties repeatedly alleged that so-and-so requested the work at issue. But this is where my case falls down a bit, really, because straight away in my head, it's like that doesn't make sense as to Rebel Wilson. So then it's like, well, who is it? Although the Jones parties repeatedly alleged that so-and-so requested the work at issue. I mean, we kind of have the statement out in the public, or it's come out, hasn't it, as part of this case at some point. Melissa Nathan said something along the lines of, Rebel wants one of those sites. That's kind of what we've heard, isn't it? So that's why my thinking here comes. That's all I can think of. What do you think? You let me know. Requested the work at issue and that such person was involved therein. Miss Case testified that, and it's all blanked out. Thus, the motion is based upon hearsay and speculation, but nonetheless cavalierly accuses an unsuspecting non-party of. Do you think it's Vin Diesel? It might be Vin Diesel again. Who else have we had brought in needlessly to this lawsuit so far? Who can we accuse of doing what, basically? And having whatever kind of interest that is in it, I guess. So the memorandum and order states, before the parties make an AEO designation, the protective order places on them the burden of determining that the information is not directly relevant to an allegation in the pleadings. For the non-parties, no such burden is appropriate. They are entitled to designate all information in this category as AEO, placing the burden to demonstrate the importance of the information for the prosecution or the defence of a claim on the counsel seeking to disclose the information to her client. So they're dying to tell Stephanie Jones something. Stephanie Jones is probably driving them mad, demanding to know who this is and all of the details. So the Jones party's pleading alleges that Tom Doe's 1 to 10 created and published 2 false and defamatory websites about the Jones parties. Putting aside Ms. Case's lack of personal knowledge as to who purportedly requested any such website, the motion does not cite to any evidence that such and such created or published anything, let alone in a manner that would subject him to liability for a defamation claim. So who is it? Who is it? Is it Justin Baldoni that's covered up? Who is it? So I think where I'm getting confused is over the websites issues, because websites is being bandied around in all kinds of terms now in this lawsuit, between the lawsuit info website, between the websites that Stephanie Jones leaks and such that she's got a problem with, to the websites alluded to that Rebel Wilson might have wanted to construct for her problem with Amanda Ghost about the movie The Deb and all of that. So my little head is a little bit confused, and I have an open head centre in human design, so I'm taking that as my permission to be a little bit confused by all of the information, a little bit overwhelmed at times. So additionally, the memorandum on order recognises that there may be situations in which a disclosing party believes information which does not fit into a specified category in the protective order is nonetheless worthy of AEO treatment. Whoever it is, it's going to cause a hell of a stink, isn't it? If the name comes out and what have you, it's going to muddy the waters for sure. And in such scenarios, such party may apply to the court for modification of the protective order consistent with the principles set forth in this opinion. I mean, if Blake gets to cover up who is her name in her alleged verbal abuse accusation against Justin Baldoni that's not related to her, she gets to cover up that name. I don't see why these shouldn't get to cover up the names that they need to cover up with. But it's an interesting argument. It's interesting the parallels and all of that. So accordingly, the motion should be denied. We're down here if you're reading. The Wayfarer parties respectfully request that the motion, the exhibits thereto, are permanently sealed, given that they include the identity of a prospective client alleged, strategies undertaken in connection therewith, and unsupported allegations of wrongdoing. See docket 688, that contains non-public and sensitive information regarding business plans and relationships, particularly undisclosed relationships with clients. So I thought that might be a little bit interesting to bring to you today, rather than just cover what everybody else has been covering. So that, yeah, I think that's it. You'll have to let me know your thoughts on it all. And, you know, you can always let me know what you've experienced in terms of verbal abuse that you've put up with over the years that you wouldn't have sought to write an affidavit about and, you know, lodge as part of a lawsuit in a completely unrelated matter. It's quite an interesting thing, really, when it's like the thing of Blake, you know, how many of us have this feeling that a big part of her problem is that she's not experienced real hardship, is that she's inventing real hardship everywhere. And it's like there's so many of us out there in the world that have really been verbally, physically, actually abused and all the rest of it, and have literally just had to take it on the chin and get on with your life, or didn't want to um, cause a situation that might make your life even worse post having the thing happen to you. Many of us out in the world have made big decisions about things that have seriously affected us and the ramifications of trying to achieve justice for that. And we sit and we look at this case and we think, well, what is really bothering her here? That he said her body makeup smelled good, that she decided that him passing along the details of his holistic practitioner was somehow fat shaming her, because the woman also helped people with like gut and weight and getting themselves right again. It's like, this is what happens when you go out into your life looking for trouble. You'll find that confirmation bias everywhere, won't you? And that's kind of the problem and the thing that we all need to be aware of, and kind of why, no matter what political party we're part of, we should always listen to the opposing argument anyway. Because it's like, I'm not political at all. I don't even really want to vote anymore, because in the UK here, I'm not sure that any party is capable of running the country. But I think you have to take your arguments where they resonate with you. Sometimes you have to get out of your head and trust your gut. And that's what I have to do more and more, especially with what I've learned based on my human design. Is like, I'm a generator, and I'm intuitive, my spleen center is defined, and all of this if you're into your human design. But I have often got too wrapped up in the thoughts in my head. It's like, if you have an open head center, then all of the information from everywhere, it's like pressure in your head, and you feel like you have to act on it. So it's finding a way to filter out what's real, what's true, what feels right to you. And that's why you often have to rely on your gut and your intuition. And kind of the girl yesterday that was accusing me of all the things and all of that. And it didn't bother me as such. What bothered me was that knowing that she's out there living her life, feeling that way, that's what bothers me. That's where my heart goes to. It's like, that must be such a hard way to live. And that's my feeling about that. And the thing, and the focus of my work as a hypnotherapist, and I'm pretty much a coach and all the rest of it because I have structured ways of working with you with hypnotherapy, but I also use conversational hypnotherapy. So I'm not hypnotizing you here, by the way. But when we work together on a one-to-one, it's like every word I say to you is important because it speaks to the way you see the world. So it's tailored to getting you the right outcome. Um, but the thing is, when you refuse to address your trauma, when you wield your trauma like a weapon to attack the world with, um, it's like trauma. When you see your life through the lens of trauma, you will attract more trauma to you because you're going out and living your life in a certain way where you kind of have an expectation that you will be mistreated, and it's like it pulls it to you, or you will trigger in somebody else something like a confrontation or something like this. I'm not saying this to blame people for the things that happen to them, but it's why it's so important to address what's happened to you, because again, when you've had a lot of trauma, you lose faith in your own intuition and your own instincts because you tell yourself that thing of somehow you got yourself into this scenario, and you blame yourself and you get all up in your head and the worry of it all because you've lost faith in your intuition and your instincts because you wrongly believe that that was what got you in trouble, or whatever it is. So it's important when you feel strong emotions like anger, like hate, like upset, like fear, that you examine where they're coming from, or at least address them, because it informs how you go out in the world and what will happen to you next as well. And it's really important to develop your intuition and to trust your own instincts. We're advised now, aren't we, as women, how many times has a situation arisen in our lives and we felt like we shouldn't go in that room, we shouldn't go in that elevator, we shouldn't do this, that there's been a feeling in our body and we've told ourselves in our head, we've overridden it, we've said, don't be stupid, don't do this, blah, blah, blah. Or, like generations and generations of conditioning of just um, ignoring your intuition and your instincts and just not upsetting anybody or not causing a stink or whatever it is. So part of my work is helping you address your trauma and your fears and your phobias and your PTSD and whatever it is, so that you're free to go back to trusting your instincts and your intuition. As what I'm finding more and more is that I get more in trouble if I listen to my head. If I trust my intuition, it's my intuition. Every time I've had a good little, like when I've been covering this case, and if I feel like every once in a while I get like a little bit of confirmation come back, which just helps me because it just goes, oh, that gut instinct I had about it was right. Because even though I didn't intellectually understand all of the information, I had a gut instinct about what was said, about the people and the personalities. I went with my gut and my intuition and the detective work that I use when I do rapid transformational therapy with people. And so this case is very interesting to me like that, and probably for many of you out there, because even if you don't on an intellectual sense understand all of the legal jargon, you'll be getting certain perspectives from your intuition. And the more that you've dealt with the pain and suffering that you've had in your life, the more accurate that intuition, that instinct will be, and the more you will be able to trust it as well and help you make decisions. So it's interesting, but do drop me a like or a comment if you can. Subscribe if you've not subscribed yet, and hype the video if you're on your phone. Just swipe to the left over the comments. Apparently that's how it works. But yeah, I'm always happy to hear from you, even if you kind of insult me, because I would rather people felt seen and heard, even if it's in terms of they feel the need to strike out or say something, because I think a lot of the problems in the world are from really hurt people who do not feel heard or represented or whatever it is. Um, and I think where this case has been helpful is in the way it has helped people bond over the shared thoughts and feelings of it. And that's it. The more we can have communications, the more we can have conversations, the more we can maybe listen to perspectives that we don't necessarily want to adopt for ourselves, but will more fully inform our own opinions, the better, isn't it? Really, that's my thoughts on it all. Anyway, thank you for watching and being here with me, and I will see you again soon. See you later.